We're live.
We're live, are we? Right. Paula, Edwina, and Heidi. Okie dokie. Good morning, ladies. Well, we've introduced ourselves, so we're done with that. Let's just tell you how we were proposing to run the day for this one. Let's just get to the day. I was going to try and put everything into 2-hour blocks, I think. So this morning we'll have 2 hours and then we'll go to a break, if that's all right with you. I know it's, it's not ideal, but and then we'll do another 2 hours and then we'll go to a lunch break. Okay, I don't know what's on the VLE, but that was the way I was going to run it, to try and get most of it, the majority of the work done before we actually go to a lunch break. And then tomorrow we have got, I think, 2.5 hours, in which I'm hoping tomorrow to do largely trust stuff and some past papers. Today, well, what I've got down for this morning, I suppose, are the first 4 worksheets. Not necessarily going through them paraphrasing, but discussing some of the issues. And also, I've looked at the past papers and I've picked 1 or 2 questions out of the past papers to show you that you can do these questions and to give you confidence that you can attempt some of these questions. And then this afternoon, well, I was hoping, I don't know whether we're going to succeed in this, to have a look at worksheet 5, 6 and 7. 5 and 6, 5 I was going to go through quickly with you because it's legacies, which I don't know what you know about legacies. And I don't know whether your background originally was English law or whether, yes it is. I mean, legacy is slightly different, so I want to go through that with you. Construction, etc. I suspect we might just leave that and I'll tell you to read that yourselves because it's straightforward stuff. And then intestacy and past papers. So
yep.
Yeah.
Intestacy is the difficult bit, so that's what they will always ask you about in the exam.
Yeah, when I was looking at the past papers, what I've noticed is that there's a recurrent theme, so to speak. There seems always to be something on intestacy going on. There always seems to be something on restrictions on testamentary freedom. And what I've noticed as well, so it's great, what happens with some of these situations is that you get a usufruct or usufruct created back in 1950. Yes, you know where I'm going. And then you lose all the remainder men, or whatever you want to call them, and then they pop up somewhere in the more modern era, and you've got to sort of have a look at the devolution of property in that I think that's quite a complex scenario, because you've sort of got to go back to 1950, and you've really got to work out where new laws came in, and does that sort of make sense? Yeah. So I've noticed that's a sneaky one. I noticed a few of those.
Yes.
I thought those were really sneaky. I didn't like those at all. Nasty. That tends, those 2 areas tend to come up time and time again, I must confess. So we'll concentrate on the past paper questions of those. But we'll start off with something nice and easy, she said, hopefully. And we're going to start off really looking at property and the meaning of property with you. Hold on, when I can find my worksheet, which I've now lost. We'll stick to, I think, probably the worksheet for this area. And I think the first questions I've asked you is really to talk about the division into, personality and realty, movables and immovables, whatever you want. Meuble.
So all three phrases: meuble, movable, immovable, realty, personalty, which are used interchangeably, but realty and personalty, from an English law perspective, are not the same thing as immeuble and meuble. And historically, because the agrarian economy was much more important to us in the past, our law actually goes into the dates upon which you're growing crops of different things, when your carrots become meuble. So you sow them, and depending on when you die, the heirs to that field might be different at different times of the year, or the crop might be different for the heirs of that crop will be different. I don't think we know. I can't remember.
No, I
anything.
can't remember. I
Asking
can't remember whether I jotted that down somewhere. But
there's an 1852 ordinance that talks about.
yes, there is.
Yes.
Yes, it is. That's right. I knew I'd come across it somewhere. Okay. Sue, I think I'm still trying to find the worksheet number 1. There you go. Worksheet number 1. So I just need you to tell me, because I expect you to do some work and stuff, really what the importance is between movables and immovables these days. Oh, sorry.
Let's not say these days.
Oh God. Yes. Well, yeah. Let's do these days, and then we can sort of go back. Does that make sense?
Yeah.
Right, folks. So why do we look at the distinction between these two different types of property? If you're shy, we can answer. Yes, I mean, I put down here until recently, things like formal requirements and devolution of property. There were different rules depending on whether you were dealing with movables or immovables. New legislation has come in, which apparently, but it is only apparently, sweeps away the importance of the distinction. But that's actually fallacious, because at times you have to keep going back to check what's going on. So I actually think the importance is still
there is still a distinction.
Yeah, and also for conflict purposes, because there's the obvious conflict thing that pops up in the paper as well. And because it is important that you know whether something's realty personality for conflict purposes. Why? What conflicts of laws. Yeah.
Dwight International Freeway.
Yes, that's right. Yeah. So which law will govern? You know, which is the governing law? So if we're looking at immovables, what tends to be the governing law here? Yes, it is. It's lex situs, basically. That tends to be the general rule. And then if we're looking at movables or personality, what tends to be the general rule there? Yeah, it tends to be the domicile. And I don't think, I mean, I've put down a bit more than that, but I don't think they need to do much more than that.
No, you may see in an exam the customary law phrase for that, which is yeah. So I can't remember which way around it is, but it's what is it?
It's
okay, wait. Meubles suivent la personne et les immeubles suivent le territoire.
Oh, what's that? Oh, that's right. No. Yes,
so, so if you have, and so it's important to remember. So, for example, if you have a Guernseyman who has a bank account in Jersey, and a lot of Guernsey people had bank accounts in Jersey because they thought that they wouldn't have to pay tax on them if the Guernsey taxman didn't know anything about it. Not true, but a lot of people thought that. So you have a Guernseyman with a bank account in Jersey and a holiday home in Alderney. Which laws determine the succession to the bank account in Jersey? Yeah. And which laws determine who the heirs are of the property in Alderney? Yeah. That's basically it.
That's it. But they do pop up in the paper.
They do.
Points. Yeah. Okay, the next question that I've put down here is about props and acques. Again, what do I say about this? I think the division of immovable props into props and acques is still important, because again we have to go back and classify property into props and acques at times. So I suppose we may as well have a look at props and acques now, and we'll pick them up a little bit later in the session as well. So if we're looking at a prop, how would you define a prop, please, ladies?
Is that something that property required?
Yes.
Yes, absolutely. Yeah. It comes about by means of intestacy. So it's important that you're looking at the history of the ownership of the property. in order to determine whether it's proper or an ACCA. And really, I don't know whether you'd agree with me, so you only really need to go back to the last transaction
Yes.
to really determine what it is. It doesn't really matter what happened before that. I mean, you can trace it all the way through, but you'll see that it changes in nature from POP to ACCA, etc., etc. But it's just that last transaction that you really need to look at and determine whether it's an ACCA. Okay, so you said anything that you get by means of intestacy, which I would agree with you, and someone else as well would be classed.
In Guernsey.
In Guernsey, sorry. Yes, yes. Yeah.
So if you purchase a property from me, if you purchase real property from me, that would be an ACCA. You've acquired it. If you purchase real property from your mum and you would have inherited it anyway, then it is still a prop.
And that's even if you've given consideration for it.
Correct. Even if you've paid for it,
yeah,
it's still a prop, which is.
When does it convert? Is it actually only put?
No, it's always a prop. If you would have inherited it and you buy it in Guernsey, and you've got to remember this is a case called Norris, then it is regarded as a prop. In Sark, they looked at that and said, well, that's nonsense because you bought it, it should be an ACCA. So the rules in Sark and Guernsey are different.
So you can't change the nature of the prop.
You can't. No.
Is that it to get ransom?
Yeah, it's a devolution where
correct.
yes, yeah. It was, yes, it was. But they were trying to work out which bit was
which bit went where.
Yeah.
Oh,
yeah. Because you got one bit under, but I can't remember this sure, but one bit under a will and one bit by means of something else. No.
If you are male or female, no. But it does matter from whom you inherit your prop. So there's a further distinction between prop which you've inherited from your father or your father's family, which are prop paternal, and then there are prop maternal are things you can inherit from your mum.
And again, the reason that that's important is this conservation of property within the relevant side of the family.
The conservation of real property is a real theme in Norman law, and it's still reflected in Guernsey law. If you think about, if any of you have had to do foreclosure of property in the UK for non-payment of a mortgage or something, it's really quite straightforward. But to try and get some real property off of an owner in Guernsey is a real schlep because of the SASI procedures, and it's because of this notion that real property is something special and sacrosanct, and not to be dissipated in the same way as perhaps you could easily get hold of somebody's bank account.
I mean, blood ties are all important, aren't they?
Yes.
And you don't want things whizzing off into a spouse's.
So just a practical example then, if I put a consideration to buy something for my mother.
Yeah.
Yeah.
So it's from the mother.
Yeah, that
I would have inherited anyway.
Yeah.
Yeah, it's the prop maternal in Guernsey.
Yeah.
If I'm a female but purchase something from my father,
It's still a prop maternal.
It's a prop paternal. It's not you. It doesn't matter what you are, if that makes sense.
Yeah.
It's what from whom you. Yeah. Yeah, that's right. Also, do bear in mind that the devolution down to you must be an heir presumptive, so to speak.
Yes.
So if you're just a cousin or something, then it's not a prop. It's an ACCA. So if it's an let me explain. If it's an inter vivus disposition to the heir presumptive, or indeed if it's a sale to the heir presumptive, then it's a prop. Are you all comfortable with that? Which is what we said. If it's some sort of inter vivus disposition from X to their cousin or their nephew or their niece or something like that, then that is not a prop because it's not to the heir presumptive necessarily. Yes, that's right. Yes. I think.
Yeah,
oh,
it might.
Yes, it might. Yes, sorry. That's yes. Yeah, that's yeah.
And this was much more important before the inheritance law came in 2011, because the rules regarding who the heirs were of a prop and an ake were different. So it doesn't really matter in testate succession, but it does matter in intestate succession. And you could see, if we really wanted to confuse people, the rules about when representation was allowed were different if it was a prop or an ake.
Yeah, we'll come on to that.
Right, okay.
Let's not do that now.
Okay.
We'll do a problem question on that, shall we?
Yes.
Right. If you look at page 3, let's just summarise props and ackes, page 3. We've gone through the props where we. Oh, sorry. Succession bit of the guide, so to speak. I don't know whether you're using the same formatting. That's why. Oh, crumbs. Oh, crumbs. It's 1.3 props and ackes. Just whiz through that. Same version, isn't it?
Yes.
Good, excellent. Yeah, okay, so it says immovable property inherited on intestacy from one's family or acquired during lifetime or of the transferor or from a person from whom the transferee would have inherited it. As heir presumptive, I should have put that in really, and that's an advancement. An ake, let's just have a look at what constitutes an ake. Anything that is purchased, gifts, anything in a will, anything by means of exchange, anything that's, I suppose, purchased for money or money's worth. Well, money's worth, I suppose, because we've done money. All of that would be an ake, and yeah, okay. I think that's about it. Okay. Are you all comfortable with that? And you just learn those. I must confess, you just learn those rules. Yes, it's only props and ackes it's only with regard to immovable property. That's a movable. Yeah. And by and large, that will devolve in the same way as ake. But we'll come back to that.
You also sometimes see conque, which is another type of property altogether, and that is of historical importance only. This was where a man married a woman who owned real property in her own name. When he married her, before married women's property law came into effect, he acquired that property by way of conque, but it was treated as an ake.
Wait, can you say that again?
Yes. So I can't remember when the married women's property law came in the UK.
1882.
Okay, 1882. Guernsey were a bit behind the times. We introduced it in 1928. Alderney, bit behind the times, 1949. Sark,
still hasn't introduced it.
1975. Which I find shocking, that in my lifetime a married woman was deprived of her property.
So you effectively is a complicated something that I would own in my own right because of.
Well, you bought
I was married, bought it, yeah.
Unmarried woman.
The practical reality of that happening.
Yeah, but
but
that's okay. You could have there are two. So for you, you can either go and you can buy a property because you're independently wealthy, or you can inherit it. So mum and dad die, and you inherit the family home. You then marry that family home by magic, then becomes your husband's property, and for him for you it's a prop. For him, it's a conque. But
I mean, to be honest, yeah, it's no different to how it was in England.
Yes.
In the 19th century. I've got my centuries.
Yeah,
19th, so I get my centuries.
Well, I just-
don't think I ever remember.
Yeah. I mean, basically, you couldn't, once you were married, you couldn't hold property.
No.
Property. It was vested in
There's
your...
a prop.
No, it could be an
It could be
okay.
anything.
It could be anything.
Doesn't
It could be
matter.
anything. It's just you lose your right. I mean, it's
The conque is only relevant to the estate of a married man, and it was only property that he acquired by virtue of the marriage. So it was property that was in his wife's name when he married.
Is there any changes on him when he dies about how that?
No, it would be treated as an ake. It's just a type of subset of ake
It's treated as an ake
for him. Correct. But if he dies first, and by and large we tend to be more short-lived, then and he left it to his wife, then for her it would then be I don't know, would it be an ake? Be interesting. If she acquired it on death by his will, even though she inherited it in the first place from her parents, it could be an ake. I don't know. This thing, it was not going to come up.
No.
It's not going to come up.
No, I mean, but that distinction went quite a while ago.
Yes, as I say,
So
19,
you're not
1928.
going to be examined on. So I wouldn't worry too much. And to be honest,
They might ask you what it is, in which case.
but I
From
wouldn't.
1928 up to
Correct.
the
Correct.
time.
She could convey it to him, in which case it would be an ake. One of the things you're going to twig, if you haven't already, when going through the notes that I was prepared, is that the laws in Guernsey, Sark and Alderney are all sometimes radically different.
Yeah.
And also you've got to keep in mind when does this issue arise, because the laws change radically over the last 100 years.
I think that I must confess, when I wrote this, it was a little bit of a shock because I didn't realise, so I don't mean this rudely, but I didn't realise that there were 3 different types of laws depending on whether you were domiciled in Guernsey, Alderney or Sark. I generally didn't know that.
Yeah.
And then what came as an even bigger shock to me, although I understand why it is as it is, was that you don't take, because of course all of the jurisdictions that I've looked at quite a few in my time, you always look at the date of death of the testator to actually check that what law is it at that particular point in time. But you don't here necessarily look at that. You look at the date that the will was actually executed.
So it could be either.
It could be, yes, I would
You need
agree.
to look at both dates,
Yes.
or you need to be mindful of both dates,
Yeah.
and you need to actually look at the documents confirmed to determine whether this is going to be dealt with under the old rules or the new rules.
Yeah. So I actually think this is quite complex. And
It is
It is quite a complex subject in Guernsey.
And lots of people, and lots of practitioners make mistakes. So even if you're not going to do this and you're going to go into litigation, this is a fruitful line
Oh, is
of
it?
work to know about. Yeah.
Mm-hmm. We've done maternal and paternal props, so I won't go back through that. But I think probably what we ought to have a quick look at next are joint accounts or joint property generally, I suppose. Because that again does pop up on the paper, and you're asked for, excuse me, you're asked for advice vis-a-vis joint property. Now, I think, might disagree on this, but I think when we're looking at joint, I put it as joint bank accounts, but it's a bit wider than that. I look first of all at what happens when you've got a husband and wife scenario or same-sex marriage scenario, and then I looked at the non-married scenario as well, because there does seem to be a difference between the two, mainly because of legislation or there are laws actually governing husband, wives, etc., etc. So if you look at, that was my page 4, so I don't know what page it is. 1.4. When you've got married couples, joint accounts, Guernsey, Alderney laws, and we've got husband and wife joint accounts, SARC laws.
You will also see reference to the husband and wife joint account Guernsey law 1966 and the husband and wife joint account Alderney law 1966. The reason that they changed the name of the law retrospectively when they introduced same-sex marriage into Guernsey and Alderney, and they don't have that law in SARC, which is why it's still referred to as the husband and wife joint account.
They're going to change the law in SARC?
So sorry, was the Alderney one also something different then?
It was called the husband and wife
yeah.
joint account. It's the
Oh,
same.
It's the same as SARC, sort of.
And you'll have picked up that some laws are bailiwick laws, some laws are Guernsey only laws, some laws are Guernsey only laws which are then replicated in Alderney and SARC. So you do, and they, as we'll see later on, sometimes people get confused, including the states themselves, as to which laws apply.
Right. If we look at, I think we look at the Guernsey law, section 1.1. First of all, can I just point out, I'm talking about, I said I was talking about bank accounts, but I'm talking about more than bank accounts, let's be perfectly frank. If you look here, it's any joint property of personalities such as, annuities, shares, stocks, debentures, etc., etc. It's much wider than just bank accounts. The law basically says that if you have a joint, if the property is in joint names, it could be a joint bank account, then if one of the parties dies, the survivor is deemed to actually take all the property, unless and until, excuse me, a contrary intention is proved. And the Macaulay, I don't know if that's how you pronounce it, Macaulay case basically says that you need, excuse me, compelling evidence to actually displace the presumption. Call it that.
Yeah, and it has to be the intention at the time the interest was acquired, not a later intention. I've had to give some advice on this recently in relation to an insurance policy where the couple are divorcing. The insurance policy was acquired in joint names and therefore it fell within the law. And if husband unilaterally decides after the policy was acquired that he wanted to sever the joint ownership, that doesn't work. It has to be the agreement of both parties or a court order.
So, practically, how could you have the insurance policy is in joint names?
Yes.
Rather than my policy for the benefit of.
Correct. This was a policy that was acquired in the name of Mr. and Mrs. And then the insurance company received a letter from Mr. saying, my wife's run off with somebody else. I would like to have half of the policy in my name and half of the policy in her name. And that doesn't work.
I mean, presumably the insurance policy they couldn't do that anyway.
They could, with the consent of both parties and the consent of the insurance company, they could do that, which is what happened in the end. But the husband or the wife could not do that unilaterally.
I mean, presumably you often get those joint insurance policies where you are purchasing realty. Am I right in saying
yes?
Yes, that's what I thought.
So if you go and get a again, we call them mortgages, but they're not mortgages.
No, then sorry.
If you get a loan from a bank to buy a real property which is secured by way of bond, which everyone in Guernsey calls a mortgage, even though it's not a mortgage, you will get insurance. The bank will require you to get insurance, so that when one of you snaps it, the life insurance will pay out, so that the mortgage is paid off. Because if you don't do that, and I've got an estate at the moment where that didn't happen, it's a complete disaster.
The money was advanced without really.
Yeah, it wasn't a professional lender.
Oh, I see. Okay.
But I don't think you do need life insurance now. I think you have to have property insurance. You're advised to, but
The problem you don't. So you don't need to, because if you don't, the bank will just will start the saving proceeding. But generally, if you're a married couple and one of you, say the breadwinner has died, but you would hope, at least if you were the person who was dead, you would hope that the survivor would be a bit upset at that time. The last thing the person needs is to then be going through a saving process.
It's really advisable, but I don't think it's actually required.
Do the banks not insist on that?
No, that's what I was saying.
Really? That does surprise me, because I thought they would have insisted on that.
Yeah.
Yeah, I'm not saying it's a legal requirement, but I just thought that it was a practical requirement, so that they would not advance unless you did that. Because in England, they won't advance unless you do that. So although it's not a legal requirement,
In practice,
it is a requirement because you can't get a mortgage.
I would certainly
As well.
advising my clients get life insurance.
Yeah.
In case it
Yeah, in case of, Okay. Household effects, well, anything purchased during the marriage, joint and, well, life assurance tends to be nominated for, held in trust for a nominated beneficiary. Where you're dealing with non-married couples, well, that legislation does not apply. And then, please tell me if I'm wrong on this, you're looking at things like the mandate, the intention of the parties at the time the account was opened, the understanding of the parties, the health, the ages of the parties, etc., etc. Am I correct in assuming that?
Yes.
Yeah.
And it'd be different. So if I open a bank account in the joint name of my daughter, that is different to me opening a bank account with the joint name of one of my partners, professional partners.
So
why? If there's a mandate and it's contractual.
Well, because there may be, again, depending on what the mandate says, but there might be a presumption that in a familial relationship, you would want survivorship to apply, whereas in a professional relationship, if
you all have to go zero to one.
correct, correct.
Yes.
So if I decide an investment, I want to buy a property and renovate it, and I get one of my professional partners who think that's a good idea, and we open a joint bank account to pay for this, and then I snuff it, there would not be the same presumption about survivorship in that case as there would if I went into exactly the same venture with one of my children, say. But it is very much, you need to find out who the parties are, what was this investment for, why are they doing this?
If you had it just to build a property with not a family member,
Yep.
a professional relationship, and the one of the parties dies, is the intention that it goes without anything different, it goes to the other person.
No, the presumption then would be that survivorship does not apply. It helps. I mean, some mandates, depending on which bank and who's advising the bank, but some mandates say, is it the intention that survivorship would apply in the opening of this bank account? Tick or no?
Yeah. But if
that helps.
If that's not ticked, then it would survivorship still would not.
Correct. Well, because it's a relationship based on contract. And if the contract, if you've agreed that you don't want survivorship to apply, then, I mean, even if that was a husband and wife, and you said, I don't want survivorship to apply, then it wouldn't. because you've got robust evidence that would offset the rebuttable presumption that the law sets up.
For example, second marriages, might be a presumption.
Yeah, exactly. You might not want your wife to get it because you might want children from your first marriage to get it. Correct.
Okay. Are we all happy with that? Have we got anything else?
Yeah.
Should we go on to children? I think we can sort of dismiss children fairly quickly.
If only it were that easy.
It's just a legitimacy point, really. I think I want to emphasise here. Since the 8th of May, I cannot get these dates into my. There are so many dates.
So many dates.
8th of May, 2008, with regard Guernsey. Then basically, legitimate or illegitimate children are treated the same. Do bear in mind that you do need to know what we mean by a legitimate child, and it's on 2.2, I think. Do bear in mind that children who are born of a void marriage was born to look at those, and they are treated as legitimate. Provided that I think that the parties reasonably believed at the time of the marriage that the marriage was valid. That's important.
No, but what? So you decide that you're going to get married on the beautiful beach of Shangri-La or wherever it may be. The Maldives was a good one. And the formalities for the marriage. So the Maldives is an Islamic country. They have completely different formalities, and you think you were married, and in fact, as a matter of Maldivian law, you were not.
Yes, there is. Void marriages are, they sort of never existed as such. So that they're void ab initio, whereas voidable ones, they have to be avoided in order for one of the parties in order for the marriage not to take place.
And I think that so I've got a friend who managed to. He was married for 10 years, and he managed to persuade people that this was a voidable marriage because he had been compelled to enter the marriage. So this is in England. And yes, I think the fact that they were all quite heavily Catholic and very religious was a factor.
So
But even if
Yeah.
your parents, say that even if the marriage is void, it's still marriage.
Yes, they're legitimate. Yeah. So you don't have to rely on the 2006 law. You don't have to rely on that. Also, if the parents subsequently marry, provided that it's not quite as simple as that, provided that one of the parents had been married, I think I'm right in saying that, at the time, of conception of the child, then the child is legitimate in that situation. It's sort of the what's it called, subsequent, that one. But yeah. Yes.
No, I don't know it doesn't, but it kind of implies that there should be something before that. If two partners have a child and they marry subsequently, does that child become legitimate?
Yeah, no, it's legitimate anyway, isn't it? By the but I think it's to do with adulterous. I mean, I don't know whether this has sort of been taken from French law, where sort of the adulterous relationship is sort of looked at slightly. But I think it's where the parties are in an adulterous relationship. The child is conceived, and then there's clearly a divorce and a subsequent marriage, that will then the child is illegitimate. So you don't have to rely on the 2006 law for that. I think that's what that's saying.
And what is foundation saying? If two people they're getting married, prior to the
Oh, it's the 66 law, isn't it?
well, no, that's just
Yeah, but
I always thought that if you had a child and you weren't married and you subsequently married, that child would be just
I did as well. I thought that was the general sort of. Oh gosh. No, that law's to do with where you've got an adulterous relationship, isn't it? I don't know what the foundation for that law is. I mean, it just. Oh, the other one. Yeah, no, I also thought that in most jurisdictions where you have a couple who at the time the child is conceived, they are not married but then become married, and it's the I can't remember the Latin, it's the per subsequens maritoria, that one. And in most jurisdictions that's the case. I couldn't find anything in Guernsey law to that effect. That doesn't mean to say that it doesn't. Are you going to look it up? Because in other jurisdictions, yeah. But if were you to marry, yes, I thought that was, yeah. No, it doesn't actually. But in most jurisdictions, yeah, I agree with you. In every jurisdiction that I've studied succession, that would be a legitimate child, where you subsequently that later marriage actually makes it legitimate. And I'm pretty sure it was pretty early on in English law when that came in, and it was. Yes, I think so, yeah. My guess is it might be customary law, if I'm not mistaken. Because in England, it came from the church recognising that subsequent marriage and legitimising the child as a result of that subsequent marriage. Now, I don't know what it is in Guernsey. My guess is it's customary law. Yeah. But I don't know. That really is just a guess.
Yeah, so I'll come back to you.
Yeah. Right. That's all that. There's a few points we do need to make. Do bear in mind that we've got the new law, so it is the law that cannot discriminate or must not discriminate between legitimate and illegitimate children. The testator can do pretty well what he wants. He can discriminate, or she can discriminate if he or she so wants. But do bear in mind, and we'll come back to this a bit later on, you can't cut the child out of their legitime because it's a state. Well, I don't want to call it state, but it's guaranteed by the state, I suppose, by the laws of the state. So you can't do that, I'm afraid.
But nowadays,
I beg your pardon? No, even the illegitimate children have got rights of. Yes, absolutely.
Okay,
yes.
So you've got to think about it again. This is the difficult bit. You've got to remember when you're talking about. So before the 8th of May. Okay, well no, let's go after 1979 and before the 8th of May 2008. You could, as a testator, say that your illegitimate children would share in the legitime. And if you didn't say that, they couldn't. Before 1979,
No, this is testacy. No, legitime is testacy.
Yeah. So if you died intestate before the 8th of May 2008, your illegitimate children did not get a look. That's really important to remember. Now, after the 8th of May 2008, until the 2011 law came in April 2012, you could not, if your legitimate children were treated the exact same way as your illegitimate children, and you could not exclude your illegitimate children from the leisure team. Now you can do what you like. But if they don't, if somebody doesn't like it, they can complain about it.
Yeah.
There is, and we'll come on to all these rules later on, a drafting point, particularly to those who are actually going to do this now. If you are drafting a will for somebody, particularly, I have to say, a male, this is more important than a male, you do not want to leave a will that says, I give my bank account or my property or whatever it may be to my children. Because with a male, you don't know as executor how many children they've got. The testator might not know how many children he's got. Women tend to remember how many children they've had. Men don't necessarily.
This is the way you get around these way of putting these applications.
Correct. We'll come on to that. But so for me, for example, if I wanted to leave my real property to my children, I would say I leave my real property to my children and embrace them. I'd go on to say who they are.
Yeah.
Otherwise, you create difficulties.
So you best to, from the drafting point, you best define who you
Name them.
Yes.
Yeah.
If you're not sure, you might not have, you might have a relationship.
Yeah, or you could say, or any other children that may be born to
Yes,
the
yeah.
thereafter,
Yeah.
which would then exclude anything that might have happened at university or.
Then that's still for your executive position, isn't it?
Less tricky, but yes.
Yeah. Okay. Alderney. Sorry, say again?
That was all good.
That was all good. Yeah. Alderney's
The
pretty.
eight,
Yeah. Alderney's pretty well the same as Guernsey, as the. As the which one is it? The 2006 Guernsey law. Pretty well the same, but that comes into effect on the 1st of January 2016. But it's pretty well the same, I must confess. And SARC, okay, SARC's got two laws. Real Property Succession SARC law in 1999, which seems to, unless I'm going completely bonkers, does the same as the laws in Alderney and Guernsey. That came into force 19th of January 2000. And the Personal Property Succession SARC law of 2007, which came into force on the 2nd of July, I think, 2007. Did I not put those dates in there? No, I didn't.
No.
All right. I think I checked them afterwards, and I think those are the dates. And again, I think that all of those.
What do you need to add?
I beg your pardon?
Should we add in those?
Yeah, I think you ought to. Yes, so I did check these. I didn't put it in the original guide. Sorry about that. The Alderney one, I think, is in there. Just check. Yes, the Alderney one's in there. The SARC ones aren't. The Real Property Succession SARC law, that was in force on the 19th of January 2000. And the Personal Property SARC is in force on the 2nd of the 8th, 2007. Okay. But they all pretty well do the same, pretty much do the same thing. I must confess, I thought all these dates and laws, they were horrendous.
Yeah.
I can't memorize them all at my age. So good luck to you remembering all these.
Going back to your question about the legitimacy of, I think that the reason the 1966 law says, it says this section 1, where the parents of an illegitimate person marry or have married one another, whether before or after the commencement of this law, and at the time of the act of intercourse resulting in the birth of that illegitimate person, either of his parents was married to a third person, then notwithstanding any rule of law to the contrary, the marriage of his parents shall, if the father of that illegitimate person was or is at the date of such marriage domiciled in the bailiwick, render that illegitimate person, if living, legitimate from the commencement of this law or from the date of the marriage, whichever last happens. I think the reason the law says that is because there was a customary law provision that meant that if you were unmarried and you had a illegitimate child and then married, that marriage subsequently legitimated the child, unless at the time of intercourse one of the parents was married to somebody else. So an adulterous relationship,
Yes, that does make sense.
rendered that customary law child, the rule couldn't, the customary law would sort of bless the subsequent marriage, would retrospectively make the child legitimate unless it was an adulterous relationship, which is why, that's the only reason I can think why Section 1 would be classed in those terms.
Yes, I think you're right. So I'm only just drawing sort of civil law stuff over, because in French law they had similar provisions where if you were a child, this went in 1929. If you were a child of adulterous relationship, you were in a more disadvantageous role than if you were just simply an illegitimate child. For example, you took half of what the illegitimate child would have taken. So I think those adulterous relationships are really frowned upon.
Even in France?
Even in France, yeah, which is a bit of a shock in France, isn't it? I'm not going to say more about that. Yes. Yes, that would make sense. Yes, that makes a lot of sense.
Sorry, that's going back to something we talked about before.
Adoption, okay. I don't have really got a lot to say about adoption. I suppose if you are adopted, then you become the child of the adopted parents and you sever links with natural parents. Absolutely. I haven't got much more to say than that.
Does that take effect even when, because there's a, and I can't remember exactly how it works, there's a point where your adopted child is still under the supervision of the parents or the, so, and then they drop out of the picture and your child is, I'm not using the right language.
It's going to be the date of the court order, surely. Isn't there a court order that?
So you may have.
So there's a period where the state is going to be, and you're not on your own, if you like, and not parental care of that child.
I don't know whether that period happens before the court order or after the court order.
Surely it's the court order.
But I think it would be, the law takes effect from the court order. The thing to bear in mind is that there's an adoption law in Guernsey and in Alderney. There is not an adoption law in Sark.
Is there not?
There's not an adoption law. But there may be provisions. Don't know. I think for all sorts of reasons, if you were a Sarkee and you needed to be put up for adoption, they would take you away from Sark for all sorts of reasons.
Really?
Yeah. Well, for a long time, so exactly correct, for that very reason. And I have an awful story about a client who was trying, I need to be careful what I say. Guernsey being a very small jurisdiction. But no, so we have a client who discovered that his parents, both of whom were adopted, actually were brother and sister.
But they didn't what?
They didn't know when they got married. They didn't know when they had.
No, really?
Yeah. So for that reason, a lot of children who were put up for adoption in Guernsey would be sent to Jersey. And a lot of children from Jersey who were put up for adoption would be sent here.
Oh, really?
So that you didn't accidentally end up marrying sister or brother. Anyway,
Okay.
For practical reasons.
yes.
Okay. I don't know whether we want to have a look at Charles, Abby, and Beth, or whether we've sort of done this to death already. I mean, we will be covering across some of these points. Let's have a look at it quickly. Charles got 3 children: Abby, Beth, Dora. Abby, Beth, born. Oops, Daisy changed her name a bit there. Born to Charles and Elaine, husband and wife. Dora is the child of a adulterous relationship. Charles and Phoebe lap dance. I like lap dances. I put them in a lot. Charles.
There's not many lap dancing clubs in.
All right, well, I didn't know that. Remember, I don't know local conditions. Charles is deeply ashamed. All in the past. Blah 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 blah. Right. Charles wishes to make wills in which he leaves all his property to Abby and Beth. Well, to what extent can he do this, ladies? What are you going to say about this? Can he leave everything to Abby and Beth? Absolutely, I agree with you. We've got the dates. So if oh gosh, we've got to take before the 2nd of.
Well, let's say that we're in Guernsey.
We are in Guernsey because we go on to
Right.
we go on to Alden in Sark afterwards.
Okay, so we're in Guernsey, and it's 1960.
Mm-hmm.
Yes, because Charles' Dora would be illegitimate.
Yeah.
Yep.
Wouldn't fall into the legitimate.
Yeah.
Real property. Then there's certain people you can leave it to, and they will be in the class. But
Absolutely.
A and B will be in
Yes.
the class, so you could exclude D.
Yep,
Yeah,
absolutely.
In fact, you couldn't have. In 1960,
Couldn't.
you couldn't have left Dora anything.
But you could, yeah, you could under movables.
No, yeah,
fact is
so
it's
you
from
could.
up.
You could. Sorry, I'm talking about real property. You
Yeah.
couldn't have left her any real property.
The real property could be. Dora,
You couldn't.
No.
but you could know.
But you could, if you wanted to, in the that postulon disponible, you can do what you like with that. So if you were not a cad and a bounder, you could give benefit to your illegitimate daughter. But if it's 2009 when this happens,
She's not listed, so it makes no difference.
well, I think actually it does make a difference.
I think it does make a difference actually.
The real two.
Both.
So in 2009, the question is, can we leave it all to Abby and Beth?
Yeah.
Yeah.
Yeah. We can do it.
No.
No, he can't.
In 2009.
No. This is before 2012.
Well, it doesn't matter what he does. Dora will get
Yeah.
her third
Yeah.
of the third. Even if he says, I give everything to Abby and Beth, he can't.
And then, am I right in saying, sorry, because the procedure, do you then have an action brought by, is it Dora?
Yeah.
To reduce the will ad legitimum modum?
So
or is that
she
the
would,
action or not?
she would bring the action. I don't know what it would be called, but
Okay.
it would be
An action to reduce the.
to Abby and Beth saying, give me my money, you've got my
Okay.
money.
Yeah. In terms of realty, you can do it.
Correct. Because we'll look at that, with the 1954 law, you can
Yeah, you
distinguish who
choose.
you want to
Yeah.
within the class.
Yeah.
And then if it's today,
Hmm.
Depends on whether that is being supporting the
does it?
Hmm.
you have a claim on that.
Well.
When you're claiming.
Well, hold on. Start with what can he do what he wants?
So you can.
Yeah.
Yes,
Okay.
Correct.
Can, but then she can really pay.
And does it matter if she has not been raised by him,
There's got to be some evidence of financial support,
hasn't it?
or some support.
They're different classes, aren't there? And it depends on which class you're going to put her within. Is it she? Yeah.
If not, if it's a boy called Dora, he's going to have a really tough time at school.
Yeah. All right.
Bearing in mind now that there is no distinction drawn between a legitimate or an illegitimate child.
Yeah, so there would be an expectation that you would require you to have education, maintenance. He would have to pay maintenance to that.
Doesn't matter.
Doesn't.
Let's say the lap dancer is lap dancing. I would imagine, not that I know, is quite remunerative, and she doesn't need to stiff the father for some money because she's in a much happier place financially.
So saying, yeah, mother doesn't make a claim to the legitimate father.
Well,
She might
do actually. She might do.
She doesn't have to, that makes
So,
sense.
Again, we'll look at this. Part 2 of the 2011 law, section 4D, simply says a child of the deceased is a person who can make an application.
Mm-hmm.
And so I don't think they have the right to make an application.
They have the right.
Look at the-
Yes.
the
Yes.
text about
That's
that.
right. Yeah. Yeah.
So in those circumstances where mother is financially self-sufficient, there's been no evidence of financial support in the past.
Well,
I think the question then becomes, did the father provide financial provision as it would be reasonable in all the circumstances for him to have made?
So each case is going to be on its own.
it is going to be on its merits, isn't it?
Because if he doesn't know anything about PC, he could conduct a work on that. Having no provision for her, there's been no financial support her life. Then arguably her claim is weaker, but not impossible.
I think.
Yeah, I mean, remember what you're looking for. You're looking for the will not to have made reasonable financial provision.
And it's not reasonable financial provision in the mind of the testator.
No.
So, for example, let us say that I have I've got 3, well, touch wood, I do have 3 hale and hearty children, all of whom I anticipate will be able to look after themselves. And then after my will, one of my children is involved in a horrible accident, which means they will never be independent, never be able to go ahead and look after themselves, and will need more financial. If I don't change my will, and then I snuff it, it may well be that I have failed to make reasonable financial provision for that child. But
Because the circumstances have changed, you say not in the mind of the testator.
Correct.
Yeah.
What about this, and the totally kind of off topic, the provision that case in the UK at the moment, where the 2 sisters are saying, pilot brother who's wealthy shouldn't take, because I know the laws are different, but the mother left her estate 3 ways, so I think about £1.5 million over the 500 each.
Yep.
2 sisters say, well, he's already rich, so he shouldn't get a share.
I can only imagine he was a really horrible brother.
So they're saying he should get less.
Oh, I don't know.
Is the purpose of a will to make financial provision for people and to improve the lot of people, or is it to divide up the estate of the deceased?
I sort of view it, other than all the other rules that are in place, it's really what the testator.
Oh, it depends which jurisdiction you're
Well, yeah,
looking
yeah,
at, because I
jurisdiction.
disagree. I think with it in English law, it probably is whatever the testator wants. You know, we give paramount concern to ruddy testator's intentions. But I think there are other jurisdictions. I mean, France, I do not think the testator's intention is paramount in France. And I think until recently that was in Guernsey as well. You know, you've got
No, I'm
forced
not
ownership
talking
in
about
effect.
I'm just looking generally.
I
Just
just-
feels different.
Yeah.
Yeah. I personally-
So if you look at if you look at the things that the courts are required to take into account, although it may be implicit, it does not say that the wishes of the testator are a relevant consideration.
No, not under the new law. Absolutely, no. I mean, there may be sort of things that, you know, construction, for example, where you're looking for the testator's intentions to construe. Well, but under the new law, I agree with you. I don't think it matters what the testator intended, because there are specific and particular guidelines that the court have to go through if it determines that reasonable financial provision has not been made under the will or under the
Yes.
testacy rules. And it's those sort of factors that the court will look at and balance, I suppose.
My person, not knowing anything about the facts of that case, I would have thought that the sisters would have an uphill struggle.
I would as well.
Unless they have particular financial needs, you know, if one of them is disabled or something, it is perfectly reasonable for a parent to conclude that he would like to treat his children equally.
Yeah, I would agree with you on that.
Are you then not saying you're looking at the
No, but that isn't the test. The test is, has the will made reasonable financial provision? And you've got three able-bodied, I'm pretty sure in the case you're talking about, there's three able-bodied adult beneficiaries.
I
And they're not in their 20s.
No, they, I can't remember, 50s, aren't they? I think. So,
And again, it might be different if one of them has given up her life to look after mum.
yeah, I agree.
And mum has
Yeah.
said, when I've gone, this will all be yours.
Yeah.
You know, there's plenty of that.
Yes, I agree with you. It's wasted. I mean, I presume, am I right in saying costs come out of the estate again? They do in England, the costs will come out of the estate. So
If they do in England, then I'm sure they would do
Alright.
here, because with one exception really, our law has been cut and pasted from the 35 Act.
yeah, it is actually pretty. Yeah, it's pretty identical.
So the only
Yeah.
difference being that in England you have 6 months from the date of grant or recognition,
Then for death.
and here it's
Why was that?
because we don't like the law.
Okay, fair enough.
So
That's fine.
we want to do
That's
completely
fine.
different.
That's absolutely fine. I don't mind.
Yeah,
That's absolutely
so
fine.
That provision about the guidelines only for since 2011.
Yeah.
There's no
Correct.
provision for
Yes.
maintenance or-
No.
correct.
No.
So if you're excluded unfairly, then it's.
What do you mean by unfairly?
Well, that you don't think there's been reasonable provision.
Yeah.
Absent fraud, duress, undue influence, lack of capacity,
Yeah.
lack
Or
of
you-
formal validity.
Oh, yes, so say you've been excluded, but you would have fallen under.
So
I go for
before,
capacity.
yeah,
Go
before,
for mental
before
capacity.
April 2012, if I had 3 children and I said I'm leaving everything to Edward and Grace, and I'm not leaving anything to Louis because his eyes are too close together and I don't like him, and I think he was disrespectful, he had bad table manners, which may be true, may not be true, completely unreasonable. Yeah, Louis can claim his leisure team, but that's it.
I think you are very much reliant on the mental capacity then, aren't you? Trying to attack the testator on mental capacity, which again I think is an uphill struggle at times, just depends on the facts.
We do, yeah. So historically, before the 2012 law came in, we did have quite a lot of disappointed heirs claiming either lack of capacity on the part of the testator or the testatrix, or undue influence. Including one famous case where my client was served with a letter for action by the graveside, which I thought was nice.
No.
Is that?
person hand wherever you're
Oh,
being.
nasty.
It's horrible. And that is the practical reasons for that, is if you change it to an intestate situation.
Then you might
Then you
actually,
might
then you
get-
might, yeah,
correct.
that's right, correct, yeah. Yeah. Sometimes it's better to have an intestacy than to have a will, isn't it?
Yeah.
Okay, where were we on this? Have we done part A? I think we have.
I think we've done A and B.
I think we've done A, and yeah, I would agree with you. What do you see? Charles made wills in 2007, movables, immovables, Abbey only 2010, executed a codicil in which he added Beth, left his entire estate to Abbey and Beth, can Dora share in any of his property? We've sort of done that as well, but what are you going to say about that?
Compared to the legislative regime
Yeah, absolutely.
under which the original.
Yes.
Yeah. And that is something really important to bear in mind, both in the exam and in practice. And that is why you still need to know the pre-2011 regime.
Can you make a codicil that brings an old will into?
Yes, you can.
Yes, you can. You just say,
Yes,
don't
you
you, that
can.
you want that.
In fact, I did that yesterday.
If you don't say anything, it just remains under the, yeah.
Yeah.
So practically, when there may be advantages or disadvantages.
Yeah.
Saying
Yeah.
So one of the
Just depends what they want.
So one of the
doesn't it?
first questions in when you've got a client that comes in and I'd like to either do a will or change a will, is you ask, have you already got a will? Find out when it was, and then you say, well, depending if it was pre-April, 2nd of April 2012, you have options. You can change it by way of codicil and keep your estate to the old regime, non-strong regime, which means that you've got legitime, you are, but you have certainty. So if you are somebody who wants to treat your children equally, but you don't want your nasty daughter-in-law to have anything, you might prefer to keep your will under the old regime.
Why is the nasty daughter?
Because your nasty daughter-in-law may be able to make an application in respect under the new Part 2 of the 2011 law.
Practically, if someone comes in and says, "Oh, I've got an old will," other than sort of the advantage of keeping it in the old regime, maybe would they just create a new will under the current regime rather than?
Yeah, but it depends what they want to do,
Depends
doesn't
what
it?
they
It really just
It
depends
depends
on
on-
what they want
There
to
is
do.
no right answer to that,
No,
because some
no.
families
Yeah.
are dysfunctional. Some families which you think are
Or-
functional. Yeah, but some, I had.
Depending on your view.
Yeah, well, exactly. Somebody I know quite well who I thought normal family, they can see about their will. Their family is as mad as everybody else is. Yeah. And they would much rather stick under the old law because they have there's people in the family who would be within the class, with people who could make a claim, who are mad as a box of frogs, and they
I
can't.
guess that is one of the old regime.
Certainty.
People are making
Certainty.
I like the old regime. I don't like the English, something like that.
I
I'm the minority.
campaigned quite vociferously that they should not.
No.
I know that in England,
Well, depending on which
doesn't
judge
it?
you come for,
Yeah.
she may well take the view that what you've done is unreasonable, and therefore, effectively, you might have forced heirship, but it's a woolly form of forced heirship that you can't predict.
Yeah, there is. I've never liked the English regime because I'm used to the French regime, I suppose. So I'm happy and comfortable with that.
or is it not all up for change?
Well, Johnny Halliday? Johnny Halliday, I think it is. Yeah, but I'm used to that. I'm happy with it. But I think it very much depends where you teach the subject. I mean, we had this conversation before you came in. That if you teach this in England, the English and taught it in Cayman, they love the 75 Act. In fact, Cayman has no 75 Act. Cayman's really bizarre in that it doesn't have forced heirship, it doesn't have the 75 Act.
So you can just be as malicious as you want.
You
to
can be as malicious as you want, and you have got to guess, folks, why Cayman, got to know a bit about Cayman, has no forced heirship like France has, and like Jersey, so Guernsey used to have, or whatever you want to go,
Yep.
and has no sort of 75/2011 law. Why are they like that? So you can do whatever you want out there.
Well, I'm going to. I think I might say maybe
Yeah, go on.
news in evidence case.
No, go on, say
I
it.
suspect that they've got lots of relationships and lots of children.
Oh, yeah, they've got that anyway. Yeah. A lot of baby mums and things, but that's not the issue. They are trying to attract high net worth individuals from civil law jurisdictions where there is forced heirship. They are trying to get them out into the Cayman Islands, and in fact, Jersey is contemplating doing the same thing. That at present is sort of being debated in Jersey as well, because they've seen what Cayman's done.
Well, how do they
You just do whatever you want. Well, no, you change your domicile and you buy, either you buy a movable property in the either you buy realty in the jurisdiction, or you change your domicile. So you've got a Cayman, so you've got a Cayman domicile. So then you suddenly become subject to. But the easy way of doing it is to buy realty there, and then that's all governed by Cayman jurisdiction, and you can do what you want with it. And there's no.
Yes.
It's good, isn't it? Sorry, anyway.
I can understand the logic.
Yeah, but that's what they've got, and that's why they've done it. But the downside of that is that the local population are left in a right quandary, because of course there are lots of normal people there, and therefore they've got no claims on estates. You know, the testators can do exactly what they want with their estates, because of course they're subject to the same regime as the high net worth individuals.
Then you've still got your leisure.
Well, you might not.
No,
Okay.
if you bring it under the new regime,
Why would you not do it?
cheaper.
Yeah.
That's probably about the only advantage.
It's a complicated will,
Yeah.
and he's only fiddling with a little bit.
Yeah. Just cheaper to do a codicil if it's a complicated will. I mean, I think it's cleaner in that situation to make a new will.
I agree. No, I agree.
Because I don't like, unless there's a reason for a codicil, and there are good reasons for codicils in Guernsey, but unless there's a good reason for having a codicil, by and large, I tend to think they're a bit messy, and I tend to like everything again, even though it does increase the cost. But
I have one client who comes in twice a year to change his German codicil, or on codicil number 12.
How many children is that?
I mean, he's not only children, but grandchildren might not be. Grandchildren might not have been thank you cards. They don't get this watch. They get something else. Right.
Long as we want war.
Yeah.
Oh, no, I don't like codicils. I must confess, by and large, for new wills all the time. But I understand why that should not be the case here. Okay, let's move us along to. Hold on. Oh heck! Oh, we got a past question to look at. I'm tempted to look at that past question a bit later on. I must confess.
Right.
It's conflicts point, but we'll have a look at that a bit later on. Because I'd like to move us on to the formal validity of a will. I must confess. That sort of pops up in rather tangential ways, I must confess, on the paper. So let's have a look, see whether we can dismiss this fairly quickly. Okay, formal validity of a will. I'm just getting a little things out. I had so many pages of notes. Don't know what to do with them all. Right, okie dokie. Okay. Some of this you may or may not know. Ambulatory in nature. Okay, jolly good. So it means that you can always make a will, revoke a will. Jolly good. First point I've got down here is that you do need the necessary intention to make a will. And I also put down there, it's a solemn act, therefore there's a prescribed form that needs to be complied with according to the law. Types of wills, non-competitive or written.
So can I
Yeah, sure.
in relation to that, something that you often get caught as a trick or a trap here, that if a document is of a testamentary nature, it needs to comply with the execution regime that would apply to wills. And sometimes you can deal with a document which you don't think is a will, but in fact is of a testamentary nature. And you can have perhaps an insurance policy, or in my line of work, you see trusts where you have reserve power trust where the settlor is the only beneficiary during his lifetime. He has all sorts of powers, but it is intended that on his death, the trust fund will be distributed in a certain manner. It is entirely possible that trust might in fact be a form of will, and you need to make sure that the document it complies with the requirements of a will, because if it doesn't, then it will not be given effect to. So a will does not necessarily have to say this is the last will and testament of.
These nominations, didn't you? Did you talk about nominations there? No. You talked about the sort of inter virus testamentary trust.
Yeah.
Yeah, I understand. What was the other one you mentioned? Sorry?
Insurance policy.
Insurance policy. But
It
you'll
depends.
nominate the beneficiary though, won't you? So it's not necessarily, you've got to comply with the requirements of the insurance company there. Am I not correct?
It depends on the form of the policy.
Oh,
So there can be policies which, when you look at them, it's just your money during your lifetime.
Okay.
Because insurance companies, in order to attract new business, sort of push the boundaries of what is insurance, and it effectively becomes a bank account. Anyway.
Okay. Right. Let's have a look. First question on worksheet 2, which I'm really looking forward to answering this one. To what extent are non-competitive wills recognised in Guernsey and also Sark and Alderney, maybe? What are you going to say about that, ladies? Looks like a fairly straightforward answer, but it's not. Just take Guernsey first of all. Does Guernsey recognise the non-competitive will? Yeah, I would agree with that. Yeah.
But it's interesting. Obviously, again, Guernsey was for many times, a fairly significant maritime jurisdiction. What happens if you're a sailor, just on a yacht race to I don't know, to the UK, and you there's a storm, and you go, oh my goodness, I don't like the look of this, and you express your views to people, and then you are in fact you do in fact drown, and they're picked up. That could be an exam question. It just says a mariner on a voyage. I don't know what a mariner is.
No, I don't. I thought they had to be in active service. I could be completely bonkers.
I think military personnel have to be in active service.
I thought mariners did as well. I thought there was some sort of I thought they had to be in some sort of service. Oh.
No,
Yeah, I thought they did, but
okay. I'm happy to.
No, I'm not.
Because I don't have a will.
No, I don't. No. I don't. No, you're going to die intestate. Okay. I don't think you're going to come within that. I could be wrong. Just do a double check on that. I thought they did have to be in service, but I mean, there's all sorts of issues that arise there. What happens if they then leave the service? What effect does that have on the oral will? But I didn't actually address that because I couldn't find the answers.
No,
So that's why I sort of avoided that. But I mean, there are issues there if they are in service and then leave the service. Does that revoke the will or not? Yes, it was. Yeah, it was brought in deliberately, I think, wasn't it?
but I think that our law is slightly different to the one that applies in England.
Yeah, in England, the coming out of military service does not revoke that, actually. Stays. But I didn't know the answer for Guernsey because it's different jurisdictions. I wasn't going to stick my neck out and say that because I thought
It's
that.
never easy to find out.
No. So I thought, if you don't know, you could say, oh, I don't know what that is, or you could just leave it back.
No, I think you're right. I think you're right. I think
You have to
I
be
think
in
it's
service, don't you? I think.
yeah.
Yeah, I think so. But as I say, I'm not quite sure when you leave the service what effect that has on the. That I don't know. I must confess, and I couldn't find the answer to that one. Yes. No. Nah, they won't think of that one.
It won't.
Nah.
It is quite good actually to find out who is sitting the executive council.
Yeah, I don't know who's setting. No, don't know.
We don't know.
No, we don't know. It's
Well, it's normally Simon Howard.
But I must confess, I've gone back through papers to try and get patterns, if that makes sense, and that's all I can do really. But I don't know who's setting the exam at all, and I don't know who's marking the exam. So,
Yeah, it's your mission to try and find out who it is.
all right, I will try and find out.
If it's Simon, I know he doesn't like Alderney work.
He doesn't like what?
Doesn't like
Alderney.
Alderney.
Alderney. Oh,
So
Therefore, he doesn't like it.
that he doesn't just like asking questions on it.
right. Form of validity. Well, it depends on the date the will is executed, whether we're talking about movables, immovables, and actually where the will is executed as well. So there's all those factors. I think on point 3.0, 3.2, top of page 14 or my page 14. All those factors have a bearing on the form of validity. So let's have a look at. Right, let's have a look at form of validity in Guernsey first of all, and let's have a look at what I consider to be the new law, new law in 2016. And to be perfectly frank, section 21. This we are on page 14, 3.3 Guernsey. Okay, we're looking at the law reform, inheritance and miscellaneous provisions, Guernsey law. And we're looking at section 21. And also what confused me was that some pieces of law call themselves articles and others call themselves sections, which really did confuse me at times.
So sections is
the new
sort of the anglicised version.
And anything in French is
articles
in article. Yeah, that's what I noticed. Yes, that's what I noticed. Right, if we look at section 21, to be perfectly frank, I don't know whether any of you have studied succession law in England, but that is pretty well nicked from section 9 of the Wills Act 1837. Sorry, did you draft that?
No, I didn't.
Sorry, I wouldn't have you drafted that. No,
all the 2011.
no, I mean that is to me that's an English piece of legislation. I must confess, sorry about that, but it is. There's it says, and let's just go through it. It has to be in writing, signed by the testator or testatrix or some other person in his or her presence and his or her direction. It appears that the testator intended to give by the signature to give effect to the will. We'll comment on this in a moment. Signature is made or acknowledged by testator in presence of 2 or more witnesses present at the same time. Each witness attests and signs will, acknowledges signature in the presence of the testator. No form of attestation is necessary. Let's just talk about all this. So it's got to be in writing, signed by the testator. If the testator can't sign, then they can get somebody else to sign on their behalf in their presence and at their direction. It appears that they want to give effect to the will, so generally, let's be perfectly frank, you want a signature at the end rather than at the beginning of the will. And you need 2 witnesses, and to be perfectly frank, be honest, it's best if all of them are there at the same time doing everything.
Correct.
You really want the testator signing and the two witnesses go, oh yeah, I saw him sign. Oh yeah, I'm going to sign that. I saw him sign. I mean, you can, for example, have the testator signing and then the witnesses coming in and the testator going, that is my signature, etc. But I don't like that. I don't know how you feel about that. I like everyone there. You do everything with 3 people there, all acknowledging they've seen you.
Yes.
Yeah, that's the best way of doing it. But,
Correct. But the law does allow
Yeah.
for the witnesses to come in separately.
separately, yeah.
I guess it's just you open yourself up for time. Beneficial.
No, I don't think so. I mean, I think it's, I think, but there were cases in English law whereby you had situations where the testator would sign, because this is the amended English law, so to speak. It's the Administration of Justice 1982 amending the 1837 law. That's what this represents. The big problem you had in English law at one time was that you had to have the 3 of them all there together. Let's be perfectly frank.
Yeah. And that was the law before 2006.
And if they weren't all there together, then the will would fail as such. So therefore, you're not giving effect to the testator's intention. You know, you've got an intestacy rather than a testacy. So I think what this is trying to do is actually facilitate. It's facilitated rather than prohibitive, believe it or not.
Well, so what did you mean by this? That it's possible for
So the witness, the old law required the testator to sign, and then the 2 witnesses to sign in the presence of the testator and in the presence of each other.
Yeah.
And now what the law facilitates is that the witnesses see the testator sign or acknowledge it. One witness signs a document, goes away, makes a cup of tea. The other witness comes in, signs it in front of the witness, in front of the testator, but not necessarily in front of the other.
so long as they both are there to witness or acknowledge.
Correct. So
Yeah,
you
the
could,
testator's got to keep on going, that's mine, that's mine, that's mine.
So you could have signed in front of one witness, and then second witness comes in, and the testator says, "I've just signed this in front of Paula."
Yeah.
Correct. Edwina, would you mind just
Yeah.
signing here?
I think this resulted from, in English law, resulted from a case of Colin where, oh God, the guy was, I don't know if you remember, the guy was in hospital, dying, and I think the nurse, there were 2 nurses who were, witnesses, and one went out to attend somebody else in the middle, and that's what led to the 82 law in England, and this reflects the 82 law.
Yeah.
And as I say, it's meant to be facilitated rather than prohibited. You want to meet a certain standard, don't you, of
So that we know that the testator means what he's doing,
yeah.
but we don't want to put in obstacles in his way that might, for some accident, have the effect of depriving the will of its effect.
Yeah.
And you'll see that when we come to look at formal validity, which jurisdiction laws you look at. Basically, in Guernsey, we can look at any relevant laws, because if it works under one of them, we'll give it effect. That's the execution of wills law.
Yeah, that was quite generous, I thought.
Because we want to give these things effect if we can.
So that's 21. What else? Witnesses. Oh yeah. Basically, anyone can be a witness, but you do need to choose your witnesses carefully. I suppose if you've got professionally drafted will, it doesn't matter. They'll be chosen for you. But persons under 14 can't be a witness. So that was a bit of a shock to me, I must confess.
What, 14?
14, yeah.
Well, we put less responsibility on kids.
All right, that's fine.
We're happy for them to work at the car for 14 as well.
Spouse of the testator can't be a will. Descendant of testator can't be a witness. Sorry, and a person who's a legatee of the spouse of such a person. In that case, they basically will keep their witnessing capacity, and they'll lose anything that they're getting under the will, which makes sense.
Except an executor. So it used to be the case that if you were an executor, and this has caught out professional advocates before, your charging clause disappears if you are a witness, but that is no longer the case. 2006.
So can you just repeat that one again?
So a charging clause in a
Yeah.
will was regarded as a form of bequest. So if you were an executor who witnessed the will, it didn't invalidate your appointment as executor, but it would have invalidated your charging clause. In the same way that if I, in my will, make a bequest in favour of Paula and Paula witnesses it, then the will is valid, but that bequest fails. Because
so the professional executor, you would be very
No, we'd be happy. Would
you
you?
wouldn't be happy.
No.
You couldn't charge you.
Correct.
That changed in 2000.
Correct.
That makes sense.
And the obvious thing there is you don't want there to be any suggestion of undue influence. Dad, sign this will. Dad, this will be living in favour for me. Sign it now. Go on, Dad. I'll witness it.
Okay, 21 applies to wills of movables and immovables. I don't know what you do in practice. I must confess, since the 2006 law, you can make one will. I don't necessarily like that. I like the old two wills, but I don't know what you do in practice.
In practice, by and large, we
Two
still
wills.
have two wills.
Yeah, that's what I do. It's cleaner on the administration side.
So the reason why, historically, because in England, of course, you have one will. In Guernsey, and Alderney and Sark, we had to have two wills, one of realty and one of personalty. And it was a practical thing. The reason being that your will of personalty, you had to give the original will of personalty to the ecclesiastical court, and that would be entered into the registers of that court. And the original will of realty would be taken to the Greffe and registered on the island's records. Now, if you own one Acacia Avenue, and you can now have a will that deals with both, because both courts will deal with a photocopy of the will. But if you own one Acacia Avenue, and you have one will that deals with your realty and your personalty, then your will be registered on the Greffe records. And anybody who buys and sells one Acacia Avenue for the rest of eternity will have a copy of your will. And in it might say, I leave my daughter Dora, who is the child of my relationship with the lap dancer, X, and to cousin Harry, who didn't think I'd remember him in my will, hello. And I would like my organs to be harvested and used for organ transplant, and all this sort of stuff that you might not necessarily want to give to a wider audience than you need to, would be there forever for the whole, for the public to look at. So typically, what we still do is we have two wills, and you can put in all the stuff about your grandpa's medals going to whoever in your will of personalty, which goes to the ecclesiastical court, and it's a public document, but it doesn't attract the same degree of publicity as your will of realty. And then your will of realty simply says, I give my real property to whoever you give it to. So it is a much more vanilla document, one that people are more comfortable in sharing. Because your heirs will want to produce the registered will of real property as evidence of title. It acts as a conveyance. Yeah. So when they come to sell the property to Mr. and Mrs. LePage, they will want to see, I see that it was inherited by Mr. Russell Clark. How come you are now the vendor? Well, here's the death certificate of Mr. Russell Clark, and here is his will of realty as registered on the island, which record shows that I am the heir.
So it's just to give the title, well, because that concept, it just passes. The property
More.
The more. Yeah.
So that's why.
It's just, it's an evidential, it's evidential. You still do sometimes as a
You don't have to
conveyancer.
register, do you?
Don't have to.
No, you can just leave it.
If I buy from you,
Yeah.
Yeah.
Correct.
Yeah.
And you still sometimes do get, as a conveyancer, the last document of title was something at the end of the 19th century or the 18th century, and it has just passed down the line through family, and no one's ever, you know, and because no one sold it.
Yeah.
Yeah.
Some farming families, you know, it just happens, and then you've got a devil of a job trying to prove that your vendor has the title.
It's like old-fashioned.
Yeah.
And if you were to take it to the grave, I've seen some wills from like the 1980s and they apply to the court.
Yeah.
Still the case.
Yeah.
But technically,
You
do
apply to the
actually
court
have
to
make
register. Yeah.
Do you actually have to go along to court?
No.
No,
It's all
You
done.
used to, didn't you?
You used to.
Yeah.
But now it's all.
And were there certain days to do that or not?
You would do it on
Almost.
conveyancing court day, so
Was
Tuesday.
it Tuesday, was it? Okay, that's the new law. But let's have a look. I said that 21 applied to movables and immovables, but we've also got a 1847 law, which still exists, shall we say, with regards to movables. And so we're on page 16, page 16. And really that's dealing with a holographic will of personality, so the testator can write his own will, if that's what he wants to do. And it's got to be dated, signed at the end. Oh, sorry, I didn't mention this. Under the section 21 of the new law, you don't have to date a will, but I think that's really stupid not to date a will, I must confess. But there is no requirement under 21 to date a will. But I would always date the thing because it sort of fixes it at a point in time for all sorts of reasons, such as capacity, revocation, etc. etc. You don't date it, you've got big problems,
So
or potentially.
So again, this goes back to the point of facilitating execution. If someone has knocked up their own will and they've had it witnessed, you want to give it effect. As a professional person drafting a will, you will, you know, I think it would probably be regarded as negligent not to have a date.
And particularly if you've then got litigation for new custody or something like that, then. Sorry, so I was talking about the 18 law, was it 47 law? So it's got to be written by testators in hand, signed, dated, and deals only with personality. No need for those to be witnessed. I don't know how common those are.
There are two things that I would like to say about holographic will. The three things. First thing I'd like to say about holographic will is it's not a 3D. I thought when I first saw a holographic will, I thought it was sort of you move and it looks like it moves. Two real things I want to say about holographic wills. One is they must be entirely written in the testator's own hand. The first female advocate, Ros Brailsford, was a partner in my firm for many years, and she had a personal campaign against the Guernsey Press Shop, because the Guernsey Press Shop sell these make your own will things.
Yes, I noticed yesterday when I popped into Smith's, there were.
And there's basically a piece of paper, and there's this lovely embossed thing that says, "This is the last will and testament of," and then you write out the rest of it. That will never be a holographic will because it is not entirely written in the hand of the testator. So it is naughty that they sell these things.
Yeah, I agree.
The second thing I'd say is, and it's an exam question, sometimes you get a handwritten letter from your client that says, "Dear Advocate Clark, I'd like you please to prepare a will for me. On my death, I want these things to happen. I'm coming in to see you next Thursday. If you could prepare it for me, I'd be very grateful. Signed, client X, and client X was run over by a bus on his way to come and see you. In certain circumstances, your letter of instruction might be a holographic will. Depending on how it's expressed.
Yes, and I
Because it has to have testamentary
intention. Yes, you knew what I was going to sort of, because I'd be worried that that's just instruction, rather than having that testamentary intention. So, because you say something like, "Oh, well, do this for me. I'm coming in on Tuesday or whatever." I'd be worried that that is not.
Yeah, I
but
think
you know, I
mean, we'll have to. Let's have a. Have we got that question?
Yeah, we have actually. Where's that one? Because there is one.
I think there has been a question in the past about that.
I thought I put it in a worksheet. I couldn't find it in the past papers.
Yeah.
Yeah. Now I think Vera will do very nicely on that one. I think Vera will. So on worksheet 2, Vera's domiciled Guernsey, 2 nieces, Ivy, Rachel, wrote to her lawyer exactly what you're saying in January, asking him to draft a will containing various legacies, giving Vera's residuary estate to Ivy, Rachel. Lawyer read the draft to Vera. She says, "It's just what I want." Initialed the document halfway down. And said to the lawyer and nurse, "You may as well initial this too." They initialed it. Lawyer promised to bring the will in the form of a draft for execution following day. Later that day, Vera dies.
And said to a visitor, "I'm going to leave my property to my nephew."
Yes. Yeah, I mean, there may be, I must confess, there may be a capacity issue there, but let's leave the capacity issue out for the time being. Just look at the, whether is it a will or not. I suspect we might disagree.
Well, I'm not sure.
I don't know. I suppose if we're looking at today's date, being the date of the today's January 2018, beg your pardon, was section 21. I suppose that might compare with section 21, but that isn't really, for me, that's not necessarily the issue. There's a bit of a problem.
So if you went through the steps, you'd be saying it's
well,
all handwritten.
But isn't
no. She wrote. Well, hold on. It's wait a sec. It doesn't really. It doesn't matter, does it? Yeah, it doesn't really matter whether it's holographic or not, does it? Because we take. Yeah. Yeah. Well, he's done something, hasn't he? Yeah. Yeah, and then there's some sort of, she's sort of initialed it halfway down, and there's some sort of, there's 2 other people who initialed her initials, so to speak.
Yeah.
And all right, she may be confused, and there may be a mental capacity point, but don't bother with that one. The question really is that a valid will? I mean, there's the first thing that worries me, of course, is testamentary intention.
Section 21(1)(b). Did she intend to
So
give effect to the will?
yeah.
Why did she initial it?
Yeah.
Did she think I might not make it until you produce a document, so let's have this in the meantime?
Yeah, I don't actually mind it being halfway down. I mean,
No,
you know, I think. Well. Not. Have we done the blank side of the sheet instead of? Yeah, I think it actually professionally. Yeah, but it does. Hold on. It appears that the testator intended by his signature to give effect to the will. Now, normally it's at the end. Problem is, Guernsey hasn't got any case law on this, but there are cases in England, which is. I don't know how much Guernsey will look to England, because that's an English piece of legislation, let's be honest. And there are cases in England where signatures halfway down, provided that, and this is important, you can't sort of get a signature at the end, they've been okay. Even a signature at the beginning, if you can't get it at the end, which I find rather odd, has been said to be okay, or down the side, it's been said to be okay. I don't like that. I always like signatures at the end, but those are professionally drafted. Or ones where you should have them at the end. Does she, hold on. Does she intend by the signature to give effect to the will? The trouble I've got is I don't know whether I think this is a will in the first place. Because I always keep coming back to the animus testandi point, the intention. She's doing something there. I'm not saying she's clearly giving instructions to her lawyer. That I would agree with. But whether there's anything more than that, whether what she's done amounts to the intention to make a will, I'm not sure.
I think yes. I think on these facts, I'm not sure that I can form a conclusion.
No, I can't form a conclusion. I've got problems with this, and I don't know what her intention is. Intention is to instruct.
Because it's very odd for someone to say.
This is where so I'm thinking that she writes to the lawyer, giving her instructions, asking him to do the draft. He then comes with the draft.
I know.
To her.
Yeah, but then he goes something like, "I'm going to hold on." He then says, "The lawyer promised to bring a will in the form of draft." Yeah, I don't know.
I don't know how. So in practice, what happens? Client says, "I want you to write all of these things. I want this." You then draft up something, and you send it to them if they're with it by email, or you write to them. They say, "Here is a draft. Can you please confirm that I have correctly understood your instructions? Please let me know if there are any amendments you'd like to make, or any changes to your instructions. And then I'll produce something on nice glossy paper, and then we can talk about how we'll execute it." So there would normally be a first draft and maybe a second draft, depending on how irritating your client, there may be 30 drafts. And so there will be an exchange of documents. Reading this, I think this is just the first draft, and the lawyer's got it right, but why has she initialed it? Because normally, the client says, "Yeah, that's fine. Can you put it on nice paper?"
You wouldn't even initial changes, would you?
But if
You just sort of instruct.
But if you're the client on email, you could just print it out.
And sometimes they do that. And sometimes they do that.
Yeah.
And then sign it in the wrong place.
Yeah. But in here, I guess the point that you're making is, did she have the intention at the point that she put the X, or is that not sufficient because she's going away to do another draft?
Yeah. So why she signed it? If she's initialing it just to confirm those are my instructions, then I don't think that this is a will. If she's saying, "Okay, you go away and do something on nice paper, but in the meantime, I don't feel so good. I'm just going to sign this."
This is what
It might be. This is what I want. Your mum says you just this will do until you produce something on nice paper. Then it might be.
I think the litigators.
They'd love that.
They'd love this one. They'd love this one. Okay. Does that make sense to you? I mean, I don't know the answer to this. So I did draft it, but I still don't know the answer.
Well, it depends.
Yeah, it just depends on. But that's litigation, I'm afraid.
One line. Could you just, and you produced it, could you just strike that out initially and witness it initially as well?
Ooh. You can, but it's litigation again, isn't it, potentially?
Yeah, you have.
Yeah, but
I would put in that situation, and I can't rush back to the office to change it. And I've noticed that I just, so for example, I'm going to leave my property to my nephew Ivy, and I've written that, and then when I get there and I go, "Oh, obviously that should be niece." And I can't produce a new document, then what I'm actually going to do is I'm going to cross out nephew, write niece. I'm going to get Vera to initial it. I'm going to initial it. The witnesses are going to initial it. I'm going to make a file note of the fact that we noticed this error beforehand. Typically, the client notices this error before you do. which is a bit embarrassing. And you, so from an evidential point of view, you covered your back.
Yeah.
But ideally, if the client isn't about to croak, I would say, I'm terribly sorry, just stand by whilst we produce the draft.
Yeah, I must confess, unless it's an emergency, I'd never alter a will. No, not by hand, I mean, sorry, I'm sorry, I'd go back to the office and alter it, I'm sorry. But I mean, I would never write on a will and alter it, because litigation, the object is, in my book, in your book, to avoid litigation, not to actually facilitate litigators. And
In my time, my practice in the
what, you just,
Like a manuscript not alteration.
really? God, we'd never do that.
You're trying to avoid it.
Really?
You're trying to avoid it.
But I think it's the way you
Ooh.
yourself at the time.
Doesn't invalidate it.
No, it doesn't, no, it doesn't invalidate it.
Litigate-
Yeah, there's potential for litigation, and my,
But yeah, you don't know. Siblings they may not be at war.
Yeah. Oh, but once there's money involved, they will be at war, or they may well be at war. So I would never ever, I mean, maybe I'm wrong in this, but I would never ever hand alter wills.
You could avoid it.
No, you can avoid it, yeah.
It doesn't invalidate.
No. It increases the
It's not
potential.
necessarily a good idea.
No. Because my attitude is always a bit of belt and braces to try and avoid litigation as best I can. I'm amazed you said that.
So let's have
Wow.
a different scenario,
Okay.
and this is something that my stepfather managed to do. He drafted a will, and then my stepsister passed away. So he got his will, and then he changed it and crossed bits out.
Oh, God.
What do we think? What do we think of that?
I don't know. Well, he just changes to say where stepsister is in your head.
He just-
that
He just crossed it out. She's dead, so.
I know what I think of that.
Well, if you're right.
No,
No, not by the sound of it.
no.
Because if you're her heirs, you might.
You have a valid will.
Yeah.
You
And
then,
then the testator amends it
that's right,
afterwards.
with no compliance with any sort
No
of section
compliance.
21 or whatever.
No.
Was it?
No witnesses.
No witnesses, nothing. Do you think that's okay? No, I agree with you. It's not okay.
No, I think the 2011 law.
Oh, does it?
I agree that it.
Oh, it does. You are absolutely right. It actually says that if you do that, you should comply with formalities again, from what I can recall, unless I'm going absolutely bonkers, which I could be, of course. It is hold on. It is section, so 25, isn't it? Section 25, 26, something like that. I'm pretty sure it is. I'm pretty sure it's.
So basically, it's not an amendment to the will, but it's not like.
Yeah,
Yeah.
he wanted to save money.
Yeah.
Even though it's
Never.
not.
Yeah, it is. It's 25 and 26. So it's 25 of the. Oh gosh.
It's
25
2006 law, isn't it? It's not
Good.
2011.
That's right. It's 2006
Yeah.
Guernsey, 2015 Alderney,
Yeah.
and it basically says where an alteration is made in a will after execution, the altered will shall be deemed to be duly executed if the signatures of the testator and the witnesses are appended
Yeah.
in the margin or some other part of the will near such alteration, or at the foot or end or opposite to a memorandum referring to such alteration written at the end of some other part of the will. So if you just sort of scroll over it, no. Yeah, provided it complies with section 25 of the 2006 law. It's 5.3.
So then there's a question, isn't there, about revocation. We're not on revocation.
Now we've got we've managed to make a will yet revoke it. Yeah. Yep.
So in my stepfather's case, the ecclesiastical court was satisfied these amendments were just ignored and had no effect.
Yeah, it's construction then, isn't it? You're onto a construction as to what these. Am I right in saying that?
Yeah.
It's going to be what they've. So if they've got no effect, you'll go back. You'll treat the will, or you'll construe it as though they're just not there.
Yes.
Yeah, that's right. Yeah. Unless, of course, the amendments touch on things like the witnessing bit of the will, if that makes sense. So if you scroll out, what would that do? If you amend a will, so you put lines through the witnesses, does that make sense? You scroll.
Why would you amend the
Oh, God knows why.
Oh,
God knows why you do it. People do weird things.
People do weird things.
Now, if you do that,
I don't know.
is that a revocation?
So the question,
Oh, nasty.
yes, because you might, because one of the ways of revoking a will is you
Yeah, you can
put
just
a line
you
through
put a line through it.
Put a line through it, saying revoke. That might be a moment.
Yeah, that might be. If you start destroying the essence of the necessity of the formal, oh God, just makes sense.
Yeah.
The essence of the formal requirements for a will, then I think that could be construed as a revocation of that will.
Say you've fallen out with your witness,
Yeah.
because you're now in a boundary dispute with your neighbour who witnessed your will. Hate them passionately, you cross them out with a big red pen on your will. That could well be a revocation.
Yeah. Also, I think the rules for revocation of what will amount to a revocation in Guernsey, I think, are more lenient than the English rules, because English rules, you really, if you put two lines through something, that may not necessarily revoke in England, but I think it does in Guernsey. So I think Guernsey is less strict, I suppose, with regard to the act of destruction. It really has to be an act that destroys the thing in England, but it doesn't in Guernsey. That's my understanding. Am I correct? Yeah.
If it's apparent from what you've done that you do not intend this will, then
Which,
you're like
yeah.
superseded on
Yeah,
it, or
that's
draw
right.
a line.
That would be okay.
Yeah.
That would.
will.
Pardon?
Well, then that's a problem.
Well,
That's an amendment.
yeah, that's an amendment, isn't it then?
The real property bit,
Yeah,
Yeah.
then that would be probably a revocation.
quite.
Nasty.
Double all matters.
Right. We're
So the
still.
answer is always seek professional advice.
Yeah, I must confess, I tend to agree.
Don't go from the Smiths. Yeah.
Oh, right.
So those are the current rules. We've got
Let's
the
go-
rules that applied before the 8th of May 2008, because there were different formalities there for a will of real property.
Yeah.
So holographic wills we've talked about. That they still applied. The law in the 1847 law was basically the same, but the two witnesses had to sign the presence of the testator. And then for a will of real property, you had to have special witnesses.
Yeah.
You had to have jurats. And so it was customary that you would go on a conveyancing court day. If your clients were fit and able, you would go on a conveyancing court day and sign your will of real property in the conveyancing court in front of two jurats. And then if your client needed an urgent will because they were on their last legs, you would phone a jurat, get them out of bed, drag them up to PH, and the witnesses and the jurats would act as witnesses. And they'd also come and see clients who were infirm and couldn't move. That was if you were to sign your will of realty in Guernsey.
And we read both together.
Correct.
Yes.
If,
Yeah.
yeah, so if you were to sign your will of Guernsey real property, you owned a house in St. Peter's Port, and you happen to be in Alderney when you signed your will, then you would have to sign it in front of 2 jurats of the Court of Alderney. If you were in Sark and you wanted to sign a will of Guernsey Realty, you would have to sign that in front of the greffier in the Seneschal.
So the properties in Guernsey, but
Yeah.
you live in Alderney,
You live correct,
Yeah.
or live in Alderney,
or you're on holiday there, and you want to sign a will. You've got Guernsey real property, and you happen to be in Alderney, or you happen to be in Sark. You would have to sign it in front of jurats of the Court of Alderney or the Court in Sark. Similarly, if you owned Alderney land and you physically were in Guernsey when you signed your will of Alderney real property, you have to sign in front of 2 jurats of the Royal Court.
It's just as long as it's in front of the jurat.
Correct.
Yes,
It
wouldn't.
doesn't have to be, if you're in Alderney, you don't have to have a Guernsey jurat.
No. So it's wherever you are. If you have bailiwick property and you happen to sign it in Guernsey, you have to jurats. If you're in Alderney, you will sign it for jurats there. If you're in Sark, you will sign it for then you're in the Seneschal. Now, often you would get clients who would come and see you at 4 p.m. on Friday and say, quickly, can you knock up a will of real property for me? Oh, by the way, I'm on the 6 o'clock plane and I'm going on holiday cage diving with sharks or doing something dangerous. And you can't possibly get jurats out, draft the will and get the jurats to sign it before they have to dash to the airport. So in circumstances like that, what you do is you draft the will, you give it to them, and you explain to them that this only works if the plane to Gatwick doesn't crash. But if you sign this will when you get to Gatwick in front of the baggage lady, in Gatwick, and another witness, that is fine because you're not signing it in the bailiwick.
You're signing it.
And
So
you
the
comply,
juice,
and
yes.
it's exactly right. Going back, so in
Same
England,
as 21.
two witnesses.
Any old 2 witnesses.
Any
will
old 2
do.
witnesses. And again,
But if you didn't do it in Gatwick and you then wanted France,
you go to the notaire.
Yeah, you just don't really is notary. Well, you can have other sorts of wills, but
So the principle of
yeah.
formalities.
Yeah.
Well, we talk about that. We have a piece of legislation, the Execution of Wills, Bailiwick of Guernsey Law, 1994. And we have lots and lots of options. This is, we're going ahead a bit, 3.7.
Yeah.
So, a will that complies with the formalities, and you've got lots of options. Although there's only 4 there are actually 8 options. So, if the will complies with the formalities of the country where you sign the will, that will be valid.
Mm-hmm.
And that if you sign with the formalities required in the jurisdiction of your domicile, that is valid. Habitual residency, that is valid.
Mm-hmm.
If you are a national of Ruritania and you comply with the laws of Ruritania, then that will be valid. And if you are dealing with real property and you comply with the formalities required in the jurisdiction where the real property is situate, that will be valid. And that can either be the laws that are in force at the time you sign the will or at the time of your death. So basically, if it's valid, if we can find a legal system in which this is valid, we'll give it effect.
And that's pretty generous.
Yeah.
What, to prevent the will?
To prevent
failing
intestacy.
Oh, intestacy, yeah.
Yeah, or failing on the grounds of the lack of formality. So we want there to be some formalities. We want you to know that you're doing a will, but basically, provided you can find some legal system and comply with it, that's fine.
And what about the situation where somebody owns Guernsey, is domiciled in Guernsey, and also owns realty in England?
Yeah.
So I understand that Guernsey advocates don't wish to do realty wills for the realty in England.
Not necessarily. Right.
Okay. No, I was just wondering.
So no. So, for example, there might be IHT planning opportunities available to somebody. Let us say that I don't know about the spouse exemption for IHT, and you come to see me, and I'm a Guernsey advocate, and you say, I want to leave my house in England to my kids,
Yeah.
and I don't mention that there is an IHT exemption for a transfer to a spouse. I could be on the hook for failing to advise you about that, which may be why some advocates are reluctant.
That's a good, that's an English.
As an English,
Yes,
English
it's an English domestic.
So
Yeah.
that's, you can make a will. No, so very easy, and very often we do that. So what we will often do is produce two wills. For a Guernsey domiciled person, maybe he's got a holiday home in Florida.
Yeah.
Maybe he's got bank accounts in Australia, got a holiday home in South. He's a Guernsey domiciled person. He comes to see you. You can produce a will. You produce two wills typically: a will of Guernsey Realty and a will for everything else. But you would typically advise, in order to avoid being done for negligence, you will advise that you might want to take advice, or you will want to take advice in Florida, England, South Africa, in that example, and make sure that this works, this is effective from a tax point of view, and also that it works as a matter of law in those countries. Because going back to the point about les mœurs suivent le territoire, I don't know, but I do, but in South Africa, it could be that I can't leave my house to my children. I have to leave it to my spouse. So,
Well, in France as well.
yeah,
So,
Yeah.
there's all sorts of false ownership.
so you can make me a will here that says my Guernsey property should be left to my stepchild, but actually that might not be effective when you actually want to apply that in France. to transfer the
Correct.
property.
And then, of course, if you're dealing with France, then there's another layer of complication, which is the Brussels Convention, which we're not going to talk about, are we? Or,
I can do, but I haven't.
I don't think that can.
yeah,
I didn't think it.
yeah.
I
So,
think that's quite complicated. Yeah.
so it's yes, and then you've got renvoi and double renvoi
That's right.
and all sorts of.
I didn't think that was on the syllabus.
No,
we
I won't.
can do it if you want to do. But I've got to say,
No, I'm sure it's on his dress.
not. I've got to.
But I think that's.
But we're a third country for the Brussels. For the purpose of the Brussels
Yes.
Convention, we are a third country.
Yes.
And if you are habitually resident or habitually resident in Guernsey, you have a holiday home in France, you can
leave it
elect
to
to leave that in accordance with the laws that
Yeah.
apply here.
Yeah.
But it's a bit more complicated than
Because I've got a sneaky feeling England and Wales have not adopted
that. They have not adopted it,
that. No, I don't think they have.
but we are a
Guernsey
third
has.
country.
Yeah.
national.
Yeah.
But, yeah.
Anyway, that's another story. Yeah.
But
We'll-
the flip example, if I have an English will, even with my and then trying to leave my Guernsey property to an old regime,
Yeah.
then if I try to save the I didn't know anything about the forced ownership at that point.
Yeah.
That wouldn't be. You can, if I'd done something
Then-
consistent with that, then you couldn't leave the property
Correct.
as per my wishes and my English will.
Correct.
Yes.
So if you have an English will that gives everything to your boyfriend,
Yeah.
but you are married, you can do that in England,
Yeah.
maybe you're
hate my husband really.
well, no, maybe you're married, but you're separated, you live apart,
yeah,
but for religious reasons you don't want to divorce,
Yeah.
and you have a boyfriend, and you've been together for 25 years.
Yeah.
I had exactly this scenario, and a Guernsey advocate prepared and so what had happened was it was a Dutch man who had a wife and kids. He was separated from his wife and had been living with this lady for 20 years. And they lived together in Guernsey as a couple. And because he had kids, he could not leave her the house. But this Guernsey advocate had drafted a very senior, and I respect this guy, it was just a mistake. It happens. He had left a life interest in the property to the girlfriend, and you can't do that under 1954 law as amended by the 1979 law. Yeah. So it was invalid.
Yeah. So he died because it
He would have done had he not come to see me and we fixed it.
Okay, that's Guernsey.
Yep.
Should we move on to Alderney? New law, same.
New law, same, easy.
So, easy peasy. Witnesses are slight difference on the age of the person, but I think other than that, everything's all right. The old law in Alderney.
Yes.
Yeah. Let's do the easy bit first. The immovables, which I think you might have covered anyway, where you said write-ins, San Data, presence of, etc.
Yeah.
So we leave that because that's easy. You sort of covered that bit. Movables. Oh yes. Well. Yeah.
I think Paula might remember this because I think it was whilst you were still with us, and Patricia had a codicil which was signed by an Alderney domiciled person in Alderney in front of one witness. And we were asked to opine upon the validity of this codicil.
Okay, a codicil signed by an
Alderney resident. So he had a will that was conventional, it had been professionally prepared, signed in front of two witnesses. And then he made a codicil changing a bequest that was signed and had one witness. And we were asked to look at this. And of course, my first reaction was, well, it's invalid. That's not signed in front of two witnesses. And that's easy peasy. And Patricia, who is a colleague of mine, said, well, why do you say that? And I said, well, the 1847 law that applies in Guernsey applies in Alderney too. And she said, why do you say that? And I said, because it's in my bar notes. Why is it in your bar notes? Because it was in Russell Finch's bar notes, and I copied his. And I had I gave talks, and I said, well, in the formalities, the will and Patricia is a more diligent lawyer than me, and she went to the court in Alderney and said, can we just see, can you get a copy of the 1847 law that was extended to Alderney? Yes, it was extended. So we have the situation in Alderney and in Sark, which is not
extended to either.
We can find, everyone thought that it was, but we can find no evidence on the records of Alderney or Sark. I've spoken with the greffier, the clerk of the court in Alderney. He can find no record. The 1847 law has been extended to Alderney. So we think that we have the position, which is not well understood, that before the 2015 law in Alderney, that you had the customary law of Normandy applying in full vigour as regards the formalities for a will of personality. Now, of course, the customary law of Normandy developed at a time when people were largely illiterate. and therefore the formalities are actually fairly limited. In order for, under the customary law, in order for a valid will of personalty to be signed, to be executed, either it had to be in writing, or it had to be an oral will made in the presence of two witnesses.
So when you say person, so a valid will of person to be executed in writing, with all that, this doesn't.
No, I didn't
Just
think we
in
know.
writing.
Just
Yeah.
I thought you did a signature. I don't know.
No, you might well.
Ooh, I can't remember. I can check that. Friday will personally will be there. I thought it was signed under the customary, but I'll check.
Yeah, but
I will
the
check.
point to make is
Oral.
you don't need witnesses.
No, you don't need
and
witnesses.
You can have an oral will.
Yeah.
So
Well, you do need
credit
Or you-
bill, was your credit bill hand?
No, it was typed. It was typed, signed. So it was in writing.
Yeah.
It was signed, and it had one witness.
That's
So
all right.
you had one witness more than you needed for customary law. So actually, the coastal was valid.
Because you don't need it.
Correct.
Before 2015.
For 2015. So this is of historical interest. This is hot.
No.
Okay.
No, it has to be in writing. Of course, in the customary law in Normandy, it would have been handwritten because they didn't have processes, but it just has to be in writing.
Also, it could be oral. That's more
Yeah,
surprising.
the oral one. So, if you go to SARC, be careful what you say about your testamentary wishes as to your personality in the pub in front of two witnesses, because this is now only of historic interest for Alderney, but it is still, I think,
Still the law.
current in
Yeah,
SARC.
I think it is.
It is an obscure
So
point.
it's still going up for personality.
Personality,
So just in writing and sign.
just in
No,
writing and signed, or oral and two
Oral or
witnesses.
two witnesses.
So in Alderney, pre-2015.
Yeah.
Yeah.
Your will was valid, it was in writing.
Yeah.
With no requirement.
Yeah.
Or it's
We think
oral,
signed, yeah,
Yeah, we think.
we think signed, or oral.
in front of two witnesses.
How does that work perfectly? You.
I have no idea.
How do you? I mean, I
How-
understand the written
what-
one. I sort of understand what you can do with that, but orally, how do you?
How do you probate an oral will?
Yes, that's sorry, that's
I have
what
no
I've got
idea.
slight problems with.
I would imagine affidavits by the witnesses.
But yes, I think yes, that's right. Yeah. I would agree.
I think we are.
Yes, we are.
I think the 1847
Didn't-
law
no,
has
didn't-
been extended,
yeah.
yeah. Which is
Which kind of,
an interesting omission. And I think the reason it hasn't been fixed is because basically the Guernsey Bar all thought that the 1847 law had been extended to Alderney and Sark.
I mean, that's quite open to it, I'm sure.
Well, it could be anything.
It's open to, yeah,
It's
it's open
worth-
to mistake, it's
Yeah,
open
it's
to
open to
everything,
mistake.
all the things that vitiate, all the reasons why you have written documents. Yeah.
Yeah.
Mm. You understand why you have oral wills in sort of emergency situations.
Yes.
That I get. But it being the default position, I find it very, very odd.
Well, the only reason it could have persisted for so long is
But why? I think there's been no move by the law officers to change that.
well, until the 2015, but look at
You're all
Alderney,
new, yeah.
look, before the 2015 law, right, Alderney's succession law was a complete basket case. And it had been for 65 years. But nobody did anything about it.
Hence why it's finding it's not. You got it.
Yeah.
And moving swiftly onto SARC. We've covered movables.
We have.
So immovables. What are we going to say about those?
In writing, signed by the testator in front of the seneschal and greffier.
Yeah.
If signed in Sark.
Okay, okay. You all happy with that? I don't know if you've got anything to say about that. Lost wills, I think you can have a read of this yourselves, because a will record to accept photocopy wills. Now you've already said them, I remember you saying earlier they will, and that's absolutely correct. The only thing I would say is that Guernsey is following Jersey.
Yep.
In this respect. And I certainly know that under Ray Hewitt, let's just get this right. If you don't have a will, if the testator doesn't have a will, and you can't find, you can't find the will, that's what I mean to say, at death, then there is a presumption that it's been revoked and destroyed by the testator. So if you trace back, you can't find it, but there was one, then the presumption is that they've got rid of it, I suppose, and revoked it. I think that's the only point I'd make in relation to the photocopying, etc. Other than that, it's just reading the notes, and I don't think they're particularly difficult.
No, so the presumption is you can't find the will. If you know, again, professional will, you send it to the client, and the client says, thank you very much. And that was 20 years ago, and now we can't find it. The presumption is that she's sorted it out.
Yeah.
However, that is a rebuttable presumption, and if she keeps on going on about the will that has been prepared by Advocate Fry 20 years ago, and keeps reaffirming it and confirming those are her wishes, then it may just be, as in my house, that her filing system is very good.
Yeah, that's not really, isn't it?
Is it, what's history?
So what I say to people is, you have a choice. We don't charge people for keeping them. I know some firms do, we don't. I say to people, do you have a fireproof safe at home? If you do have a fireproof safe at home, then you might want to keep it at home. But we would like to keep a copy here, please. If you do not have a fireproof safe at home, my suggestion is that you have the copy and we have the original, because you do not want to exit this life stage left through a house fire, only then to discover that it is also torched your will.
And the expense of then having all the
Yeah.
to have the court acknowledge
Yeah.
basically.
Yeah.
So, and again, most practices keep a record of all the wills they have produced, and so when somebody comes in and says my mum died at the weekend, then what we tend to do is, because there are only a small number of law firms, we contact each law firm to say, do you have a will for Mrs.
Okay. That's probably a good place to take a 10-minute break.
Yes, please.
And then we'll go on to, I think probably we can do capacity pretty quickly.
Yeah.
Because it's just, it's the same thing, but it's just learning the notes. Let's be perfectly frank. I don't think there's anything technically difficult about capacity. Oh, we do have to stop that thing. I know we've got to stop it before the 3-hour mark as well, but I think that's Russell, that's beyond my capabilities yet again. Okay, just 10 minutes to get a cup of coffee, come